In this video, we'll discuss some of the problems that we framed on the law of contract. So, one must be carefully listen these problems, and while listening these problems, I request every one my viewers to keep a notebook and a pen in your hand to write down the very solutions and how these problems are solved. So, the first problem is that H picked up a diamond on the floor of K's shop and handed it to K to keep it till the owner appeared. In spite of wide advertisement in the newspapers, no one appeared to claim it. After the lapse of some weeks, he tendered the cost of the advertisement and an indemnity bond and requested K to return the diamond to H, but K refused. What would be the result and why? So, the very solution for this problem would be that according to the provisions of section 168 of the Contract Act of 1872, finder of anything lost by any person has right except the real owner. He can retain the thing as a belly until the real owner is found. So here H will succeed because K, who has retained the goods of third parties, has no right. And our second problem is that an uncle wrote to his nephew, who was already engaged to be married to X. So he wrote, I am glad to hear of your intended marriage with X, and as promised to assist you at starting, I am happy to tell you that I will pay you as 10,000 yearly during my life or until your annual income amounts to rupees 20,000. The nephew had not receiving the amount, so advise him. No, the nephew will not succeed as there is neither a contract nor a consideration. It was simply an offer by the uncle, which is not shown to have been accepted by the nephew. Moreover, there is no consideration at all, and according to section 25 clause 1 of the Indian Contract Act 1872, an agreement without consideration is void unless it is in writing and register. So, this is the solution to the second problem that just we have discussed. And now we'll go to the third problem, and that is a contracts to sell and deliver 50 mounds of salt to be at a certain price to be paid on delivery. A breaks his promise. How much compensation will be get from A for this breach? So the very solution to problem number 3 is that the problem here is similar as to the provisions of section 73 of the Indian Contract Act. So, in this case, a contract to sell and deliver to be 50 mounds of salt at a certain price to be paid on delivery. A breaks his promise. B is entitled to receive from A by way of compensation the sum, if any, by which the contract price falls short of the price for which we might have obtained 50 mounds of salt of like quality at the time when the salt ought to have been delivered. And the fourth problem is that A instructs B, a merchant, to buy a ship for him. B employs a ship surveyor of good reputation to choose a ship for A. The surveyor makes the choice negligently, and the ship ought to be unseaworthy and is lost. So, what is A's remedy, and against whom? The very fact of the problem, as according to the provisions of section 194 of Indian Contract Act, an agent of the principal is authorized to employ another person to perform such part of the business of the agency as is ensured and entrusted to him, and according to section 195 of the Act, in selecting such agent or person for his principal, an agent is bound to exercise the same amount of discretion as a man of ordinary prudence would exercise in his own case. And if he does this, he is not responsible to the principal for the acts or negligence of the agent so selected. Thus, where A instructs B, a merchant, to buy a ship for him, and B employs a ship surveyor of good reputation to choose a ship for A, The surveyor makes the choice negligently and the ship turns out to be unseaworthy and is lost. B is not, but the surveyor is responsible to A. And now we'll go to problem 5, and that is A bales 100 bales of cotton marked with a particular mark to be without A's consent mixes 100 bales with other bales of his own bearing a different mark, at whose expense is A entitled to get back his own bales. So the very facts of the given problem, as per the provisions under section 156 of the Indian Contract Act, if the bailee without the consent of the bailer mixes the goods of the bailer with his own goods, and the goods can be separated or divided, the property in the goods remain in the parties' response respectively, but the valley is bound to bear the expense of separation or division and any damage arising from the mixture. Thus, in this given problem, where A bales 100 bales of cotton marked with a particular mark to be without his consent, B mixes 100 bales with another bales of his own bearing a different mark. A is entitled to have his 100 bells returned, and B is bound to bear all the expenses incurred in the separation of the bells and any other incidental damages. So, our next problem, and that is the number 6 problem, is that A not being authorized thereto by B demands on behalf of B the delivery of a chattel, the property of B, from C, who is in possession of it. She refuses to do so. Can B demand damages from C for his refusal to deliver the chattel? The problem is based on the provisions of Section 200 of the Indian Contract Act 1872, an act done by one person on behalf of another without such other person's authority, which, if done with authority, would have the effect of subjecting a third person to damages or of terminating any right or interest of a third person, cannot by ratification be made to have such effect. Here, in this given problem, A not being authorized thereto by B demands on behalf of B the delivery of a chattel, the property of B, from C, who is in possession of it. So the demand cannot be ratified by B so as to make C liable for damages for his refusal to deliver. So now we'll go to problem number 7, and that is C the bride and D the bridegroom or minors at the time of their marriage, which was settled by A and B, who were respectively the fathers of both of them under and said agreement in writing. A term in the said agreement was that the father-in-law of the bride was to pay a certain amount to the celebration of the marriage. The father-in-law did not make the payment. So, advise C. So, the problem is based under the provisions of Section 25. The agreement must be in writing and registered under the law for the time being in force. For the registration of documents, but here the agreement, though in writing, is not registered, hence she is helpless and she is unable to do anything. So now we'll discuss the next problem, and that is relating to number 8. The problem is that A's son has forged B's name to a promissory note. B, under the threat of prosecuting A's son, obtains a bond from A for the amount of the forged note. On A's failure to pay, B files a suit on the bond. Will A succeed? So, here it is yes, A will succeed if he shows that the bond was obtained under the threat of prosecuting a son. Threat to prosecute is an offense under Indian Penal Code, and therefore coercion within the meaning of Section 15 of the Indian Contract Act 1872. Hence, the consent by A for bond is not free. Consent within the meaning of Section 14 of the Indian Contract Act, which means consent is said to be free when it is not caused by coercion as defined in Section 15, or undue influence as defined in Section 16, or fraud as defined in Section 17, or misrepresentation as defined in Section 18, or mistake subject to the provisions of Section 20, 21, and 22. So consent is said to be so cast when it would not have been given, but for the existence of such coercion, undue influence, fraud, misrepresentation, or mistake. Therefore, the bond was obtained without free consent, hence it is voidable at the option of a within the meaning of section 19 of the provisions of Indian Contract Act. So this is how we found the solution to these 8 problems as we framed under the law of contract, and all the other problems we would like to discuss in our upcoming